They admit the problems, and they want to do better. My question for them is, how can we help? We want our treaty partners to succeed for the benefit of the children and their families. We have supported judicial training in countries where judges are not familiar with the convention. We have trained central authorities on how to manage cases. We have brought foreign officials to the United States to learn from their counterparts. We connect countries that have resolved enforcement problems with those that are still struggling. We highlight our concerns about understaffed and under-resourced central authorities with those who can make a difference. We work closely with our colleagues in regional bureaus and at our embassies to develop tailored strategies for each country. We use every opportunity at all levels to talk about problems and look for solutions. Some of these conversations are with key government officials. Others are with members of civil society, members of the legal community, and other stakeholders. We use the media to raise public awareness and try to influence government actors. I've written op-eds and conducted interviews with major foreign newspapers targeting problems in their countries, such as Brazil and Korea. We also use démarches to formally convey our concerns and demands and to make these a matter of record. I know there are many who believe that we should withhold assistance. I note that our foreign assistance is given to promote our national interest, such as counterterrorism, counter-narcotics, regional security. Issues I know that this subcommittee is very much focused on. We engage in promoting the rule of law, an important goal that assists us in the implementation of the Hague Convention. We weigh whether withholding assistance will achieve the results we want by influencing those who can make a difference. I do not work alone. A team of dedicated colleagues in the Office of Children's Issues and throughout the department support me in thinking creatively and acting constructively. I know that progress does not come quickly enough for the parents and children traumatized by international parental-child abduction. My colleagues in the Office of Children's Issues are committed to assisting left-behind parents seek the return of their children, which we know is too often a long and painful process. We wish it were otherwise. That is why I will continue to press our treaty partners to live up to their obligations and urge other countries to join the convention and implement it fully. In doing so, I and my colleagues appreciate the support of Congress in demonstrating that resolving and preventing international parental-child abduction is a priority for the entire U.S. government. Thank you. I look forward to your questions.
Thank you very much. We are joined by Dr. Barra. Thank you for joining us today. I have just some opening questions, then I'll yield to my colleagues. The 2023 report identifies 14 countries which were determined to be non-compliant. Of those, 8 are countries with the Hague Convention in force with the United States. In all but one of those cases, the report identifies judicial performance or delay as contributing to the determination of non-compliance. And I'm wondering, in the case where a judicial determination is not in conformity with the treaty, or the process applied is not compliant with the treaty, is that case still defined as resolved?
That is something we look at case by case. And when we have a team of attorneys in the State Department, and we often ask them to review a case to see whether it is in fact compliant with the convention. And if we start to see trends where that's not the case, we will raise that with the foreign government. I thank you for the question about judicial delays. That is something that we have identified as a problem, as you say, in several countries, many countries. When I meet with judges in those countries, and I will note I have visited Ecuador, Argentina, Peru, Brazil, and India over the past year, I find that it's typically not that the judges are deliberately making the wrong decisions, but that they don't understand the convention, which is why we have made such a concerted effort to promote judicial training, judicial education in those countries. In Brazil, for example, the judges of the Supreme Court have spearheaded not just writing guidance for judges throughout Brazil, but have hosted 2 separate workshops to try to raise awareness among the judges in Brazil about how to implement the convention correctly. These are the kinds of activities that we're trying to support and promote, not just in Brazil, but in other countries as well.
Let me just ask you, when there is a problem in a resolution that's not been following the fundamental principles of the Hague Convention. Where is that documented? Does it go into that file? Does it find its way into the report? Or
It would be obviously part of the case notes for the case, but it would also be, the question is what happens next? What are the next steps that we can take with that parent to try to find a solution of some sort?
with regards to non-treaty countries, what steps, if any, have been taken to review the terms of prior MOUs entered into between the United States and Egypt and Jordan?
That is an excellent question. Memorandum of understandings are one way to memorialize a joint commitment to look at cases, to look at the issues, to try to find solutions, short of a binding or legal remedy, because obviously you're only using the legal remedies that are already at your disposal. They're a way to get people to the table to talk. I was actually in the Office of Children's Issues in 2004 and 5 when we entered into the MOUs with Lebanon, Egypt, and Jordan. Because they're not binding, they're only as good as the commitment of both parties. And I think we find times when, for whatever reason, sometimes governments lose track. But I can tell you, I will be going to Lebanon and Jordan early next month, and this will be a topic of discussion. But we do look at MOUs to say, is this going to get us the dialogue that we need to try to resolve cases outside of the Hague Convention? Is it going to detract from any efforts, depending on the country? Is it going to detract from ongoing efforts to get the country to move to Hague? Do we need it? Sometimes we have the understanding without the memorandum, and we have countries that we work with very collaboratively on an ongoing basis without a piece of paper. So we do weigh all of these factors when we look at each country and what might work best in that circumstance.
Could you tell us how often does the interagency working group meet? And would it be possible, protocol-wise, if perhaps I and my ranking member and others were to sit in on one of those?
The interagency working group meeting, which again, thank you very much for that. The Act set that up, and it's been a wonderful success. It really has strengthened our interagency working relationships with the wide range of agency partners. Before the pandemic, it was meeting biannually. With the pandemic, that has gone to an annual basis, but we're hoping to get back to the biannual pattern of meetings. That said, I think even just those biannual or even just the annual meetings really helped create the network of contacts that we need on a day-to-day basis. The next meeting is tentatively scheduled for early August. The last one was in August of 2022, and we will be hosting it. So I think we can have discussion over who comes. So thank you.
I appreciate that. Thank you so much. One of the provisions we embedded into the Goldman Act was to encourage families left behind, parents, to be in touch, for you to convey to that person, or persons, if it's the whole family, that their congressmen and 2 U.S. senators might be of enormous help. That is there's nothing but value added. I don't think too many of us have messed up when it comes to these cases, but it does add a certain sense of urgency because of the power of the person, just the advocacy we bring to bear. How has that been working out?
So that has become a standard practice. Thank you very much. When the Office of Children's Issues opens a new case, when a left-behind parent contacts them and they open the case on their behalf, they also provide information on who their senators and member of Congress is so that they can reach out to them. We really value the support that we have from members of Congress because it does make a difference. When I travel overseas and meet with foreign governments, I can very accurately say this is an issue that is important, not just to the administration, but to the Congress as well. It's an all-of-government concern, and that is very helpful.
Just let me ask you, Japan was designated as non-compliant, as you know, in the 2023 report, with reference to a number of cases, quote, voluntarily resolved. How does the report define voluntary resolution, which is consistent with the purposes of the treaty? While the report indicates that judicial authorities rendered timely decisions, it also indicates that the U.S. is not aware of a single abduction case in which a judicial order related to international child abduction needed enforcement. To your knowledge, has there been a judicial determination made pursuant to the treaty to return any abducted child to the U.S. in the last year And can you direct me to where that information is to be found in the report?
So with regards to Japan, a voluntary resolution would be where the parents actually came to some sort of a decision regarding the child, whether that access, return, or whatever the case might be, whatever the parents decide. And obviously that's something that we appreciate because it can be less traumatic for everybody.
But if you yield on that one point,
Yes.
the undue pressure that many of these families have experienced, these left behind parents, maybe years, it's bankrupted them, perhaps, or certainly the pain and agony, they're more likely to accept terms and conditions that are less than fair.
I totally agree.
So how does, if it doesn't comport with the treaty, how do we remedy that?
It is totally not an ideal situation in many instances. I do agree with that. And again, voluntary it is where the parents have come to some sort of an agreement. As far as returns, you're absolutely correct that Japan acceded to the convention, and then we realized that, yes, they had acceded, but they were unable, under their own laws and processes, to enforce return orders. So judges might have been making the right decisions, but they weren't being enforced. That was something that we pressed Japan on because, again, what's the point of the convention if the orders aren't being enforced? Japan subsequently passed legislation to give teeth to their enforcement orders, and I'm pleased to say that since 2021, Japan has successfully enforced all U.S. Hague cases in which there was a return ordered. So that's a step forward. Again, it's not something, we're still watching, we're still monitoring. That's only been 2 years. And we want to see what happens, going down the road. But there is some progress there that we want to take note of.
Thank you. Ranking Member Wild.
Thank you, Mr. Chairman. As I was listening to you, I was reflecting back on my own legal career before I came to Congress, which spanned 30-some years. And at the very early point of my legal career, I did some domestic relations work. Thankfully, that was a relatively short period of my legal career. But there was nothing more challenging than difficult custodial arrangements, and I cannot even imagine the added piece of an international abduction and how that gets resolved. And so I commend you on the work that you've done and are continuing to do in this highly emotional space. You've been a consular officer yourself. I understand that they are extremely important in the process of ascertaining an abducted American child's welfare and whereabouts abroad. Can you discuss that a little bit so that those of us who haven't been in that role understand what the consular officer does and what kind of factors will contribute to his or her success in that role?
Thank you for that question. We're always happy to talk about what we do. We conduct welfare whereabouts visits on children who have been parentally abducted at the request of their parent. And
You mean
this
if
is
the parent who...
the left behind parent.
The left behind
The
parent.
left behind parent. Sometimes we conduct them when we have our own individual or separate concerns about the child's welfare. We have the authority under the Vienna Convention to do that at any time if we have concerns. One of the challenges is often that is getting access to the child, and sometimes negotiating with the taking parent how and when and where we can meet the child. We emphasize that we are concerned about the child's welfare, and we also recognize that our visit with the child and our report to the left behind parent about how the child is doing, how they are faring, how they're doing in school, may be the only information that parent has or has had about their child in years. And so it's so important that we get the details accurate and that we convey to them as much as possible about the child's conditions, how they're, again, everything information we can get. So we have guidance that we provide to consular officers. We do a lot of training on this so that they understand what their role is, that they understand how to negotiate that visit to make sure that we can get to see the child. And I will note that even this week, we are running our primary training program on responding to international parental child abduction focusing on Middle Eastern countries, or posts in the Middle East. So that's going on right now. But again, this is an important part of that because these visits are really critical in providing the left behind parent with information on their child.
And that's assuming that you can ascertain the whereabouts of the child.
That is, and that is something that we obviously will be working with. If we don't have the information from the left behind parent, if they don't have that information, then we would work with local authorities to try to locate the child. And we, again, may have to be very creative in that, sort of looking at various ways and various contacts that child might have with other people to see how can we find them, how can we find.
So is the consular officer's security a concern? Safety and security?
It is, but that depends on the country, it depends on the conditions, it depends on the individual case, obviously. And that is something that a consular officer would consult with the regional security officer as to what steps might need to be taken in order to conduct that visit. We also, I think, one of the, if you will, silver linings, such as it is, of the pandemic is that even if we can't get physically to meet a child, we sometimes can meet them virtually. It doesn't entirely, compensate for the in-person, obviously, but it's sometimes better than nothing if we can't get anything else.
And if you have trouble ascertaining the whereabouts of the child, are there countries that are more cooperative in assisting than others?
Again, yeah.
And assuming that the answer is going to be yes, can you tell us which countries are not particularly cooperative?
I think where their countries are not cooperative, it's often because they also have a problem in locating children, period, which is one of the criteria we look at in the ICAPRA report. For example, countries that their law enforcement capabilities are under-resourced or untrained, or perhaps they don't see this as a higher priority as other law enforcement matters. When I was traveling in Ecuador and Peru, this is something I raised with local authorities. Not that they can't always find children, but when they have trouble, we want to make sure that they have the resources and that they understand this is important too. So I don't have the list of countries off the top of my head where this is an issue, but when it is an issue, we raise it.
And are there additional tools and resources that need to be provided to consular officers in this role that they don't currently have, that are on their wish list?
I'll have to
that
take
would make the job easier?
I'll take that back and consult with my colleagues.
Please let us know.
I will.
If you would. I'm going to yield at this point. Mr. Chairman, I have other questions, but I'd like other members to have a chance.
Dr. Barra, thank you.
Great, thank you, Mr. Chairman, and again, thank you for the work that you're doing. Obviously, a very challenging situation. I'd like to address. I'm the senior Indian American member of Congress, and India hasn't acceded to the Hague Convention, and certainly want to talk about that a bit. In my pre-hearing reading. Read some of the reasons the Indians have given for not acceding to the convention, one of them being that many of the taking parents are victims of domestic violence. And India still is a place where you have a lot of arranged marriages. You have brides that will go to a foreign country, let's say the United States, where they really don't have any other support system. And work closely with South Asian, Indian American organizations trying to address domestic violence. So that's a very real concern. That said, just from your perspective, working with India, so I can see the scenario where a mother flees with their child back to where their parents are in India. That said, how do we address that issue of domestic violence, but also reuniting family? And that obviously is a tough situation.
Well, thank you for that question, and thank you for your interest in India, because again, that is one of my high priorities, is working with India and the Indian government to resolve some of the really heart-wrenching cases that involve both mothers and fathers as left-behind parents. I think that's something that we constantly remind the Indian government of. It's not all women taking their children to India, it's also men. Domestic violence in any case is a complicating factor, but my point, as I've raised with my interlocutors in New Delhi, and here in Washington when we've met for our bilateral, annual bilateral dialogue with the Indian government, is that if a woman, let's say, is the victim of domestic violence here in the United States, she needs to avail herself of the protection and resources that are available in the United States. We have federal, state, and local programs to protect and support victims of domestic violence, that feeling that they have no option but to take their child to India or to whatever country is not the option. It should not be the option. And so we are actually talking about active outreach to the Indian American community about this issue. Because if we can prevent these abductions, we're so many steps ahead. But working with the Indian government is definitely very, very high on my radar screen. I've made it a career goal.
Certainly let us know, or let my office know how we can be helpful amplifying this issue within the diaspora here in the United States, because it is a very real issue.
We will definitely be talking to you.
Great, thank you. Are there specific things that we should raise with the Indian government to address this issue? Because that would be helpful.
We would welcome the opportunity to meet with the caucus to talk through some of this, to see where we can collaborate and in our conversations with the Indian government. Again, we have our annual bilateral meetings, but where this is always a top agenda item. But besides that, we have ongoing, fairly frequent discussions with the Indian government in New Delhi, the Ministry of External Affairs, and the Ministry of Women and Child Development, which is the lead agency on this. And we are, most recently, our embassy in New Delhi hosted a judicial seminar on international parental child abduction and other children's issues, which brought together over 400 members of the legal community and civil society. So we want to raise awareness within India about the problems and really set the record straight on what's happening and the trauma that this causes. So we'd love to come to you to talk about how to amplify that message.
Great, certainly, and I look forward to working with you and doing what we can to kind of amplify that both here within the diaspora, but also within India. Thank you, and I'll yield back, Mr. Chairman.
Thank you very much, Dr. Barra. I'd like to now yield to Dr. McCormick.
Thank you. Thanks for taking time out of your busy schedule to be with us here today. As a youth minister for 20 years and as a father of 7, this is a very near and dear subject to my heart. As a guy who's seen people been brought into the ER after being trafficked, it's even more sobering to me. I'm always worried that we get it wrong in the government, though, that we're not doing things that are effective. We're just doing things that end up being messaging pieces because we care. Sometimes churches do the same thing, right, where we donate a bunch of money and then we say, look, we helped, and somebody bought a Ferrari and nobody actually got any downwind consequence from what we sacrificed for. In your opinion, since you're the expert, that's why you're here, what do you think we have done right, and what have we done wrong or we could do better into the future as we're trying to solve this very complex issue, which when you're dealing with foreign countries, as anybody who's been overseas multiple times would know, in the military, even when you have force, it's hard to get things done. And I got a friend of mine who's a merc who does child retrieval overseas of child trafficked people, over 100 women so far. And it is a complex business. And I'm not sure we have a cornerstone on all the things we could do right. What could we do better?
Thank you. That's a really good question. What do we do right? I think that when we develop our country engagement strategies, again, in consultation with our regional bureaus in the State Department, with our embassies abroad, and with our stakeholders, our left behind parents who provide a very valuable input, when a government recognizes that they have a problem, when they want to do better, it's helping them identify what steps they can take and how we can support them in doing that. So whether it's judicial training, whether it's law enforcement training and trying to locate missing children, all of those steps. I think one of the things that we could do better, which again is a priority, is drawing on the experience and resources, not just of the State Department, not just of our law enforcement agencies that can provide training and expertise to their counterparts, but again, looking very broadly at who's doing what and who can be part of this equation, who can help resolve some of these challenges. Again, left behind parents are a very valuable resource and provide very valuable information, but it's also raising awareness, helping get the word out. And I think, as was mentioned earlier, humanizing the issue so that foreign governments understand the cost to the children and to their families. I was very moved, as we all were in the Office of Children's Issues, when a mother whose child was returned from a foreign country sent us a video of their return at the airport. It wasn't just the mother and child. It was the entire family, the little girl's friends, her classmates, and you understand how this impacts not just one family, not just a nuclear family, but an extended family and a neighborhood and a community. And I think helping raise awareness to that fact is something that we should all be doing.
I apologize for not being here during your open remarks, and perhaps you've already covered this, but if you could single out 2 or 3 countries that specifically have been egregious in their behavior or their inability or resistance to cooperating, I would like you to name them.
That's a good question. I think if our report, even the cited countries, the countries that we've cited in our report that I have visited at least, have wanted to cooperate. But they need guidance, they need support, they need help in figuring out what to do. Obviously, there are countries that are totally not cooperative, Russia being one of them. And there are other countries where we don't have diplomatic relations, such as Syria, where any case is even more challenging because of that, because we have to work through third parties to try to just get information. Those are the countries that are extremely difficult and not cooperative on anything. But again, fortunately, we often don't have many cases, if any, there as well.
Kind of makes sense. I imagine the majority would be south of the border, and into those countries, is that correctly?
I think our countries in Latin America, the majority of whom are Hague Treaty partners, even those that we have cited as being non-compliant, my experience with talking to their governments has been they do want to do better. They want to do better.
I was referring to volume rather than actually
volume.
consequence.
Oh, yes. Oh, absolutely. You're absolutely right.
But thank you very much. I appreciate it, and with that, I yield.
Thank you very much, Doc. Ms. Jacobs?
Thank you, Mr. Chairman, and thank you for being here. First, I'd just like to acknowledge my constituent, Astrid Johnson, who's here in the audience. We're going to hear her story in the second panel, but thank you so much for being here and for your advocacy. I want to follow up on the question that my colleague, Dr. Barrett, asked around this question of domestic abuse. In 2020, the official guide to good practice on the Hague Convention's grave risk exception was published, and it clarifies that this exception does not require, for example, that the child be the direct or primary victim of physical harm if there is sufficient evidence that because of a risk of harm directed to a taking parent, there is a grave risk to the child. Last year, actually, one of my constituents fled another country to the United States, fled another country to escape her abusive husband, who eventually filed a Hague Convention petition to obtain custody of their 2 children. So I just want to ask you, I know you said the recommendation is you tell people to avail themselves of the services here in the United States. I think we know that those aren't always perfect. As I said in the guidelines, that actually this is supposed to be taken account. So how do you view this grave risk exception? What steps are you taking to ensure that mechanism, it provides sufficient protection? And how have you made sure we're playing a constructive role in ensuring that these guidelines are implemented as intended?
Thank you for that. This is an issue that is of concern, I mean, obviously not just to us, but to the entire international community that works on the Hague Convention. It's something that is frequently discussed. With regard to 13B, the exception for grave risk to a child, which is intended to be used in exceptional cases. Obviously, domestic violence against a parent can affect a child. We all know that. The convention talks about returning the child to their habitual residence, not necessarily to the care of the other parent. although often that parent does have a custodial rights, usually does, always does. But one of the trends that has become incredibly important in these cases, especially when there's concerns about domestic violence, is direct judicial communication. When I worked in the Office of Children's Issues previously, this was a foreign concept in many countries. In fact, in many civil law countries, judges were prohibited from speaking to other judges about a case. With the creation of a Hague network, a Hague judge network of experienced judges around the world in all the different countries, partner countries, this has encouraged and facilitated direct communications between judges. So, for example, a judge hearing a case in a foreign country who has concerns about the possibility or the allegations of domestic violence can speak to a judge, in this case in the United States, to say what protective measures will be put into place. If I order this child returned, what kinds of protective measures would be put into place to protect the parent and the child? And that's something that has been very useful in resolving these cases, consistent with the convention, returning the child to their habitual residence, while still respecting the protection of a victim of domestic violence.
And I appreciate that, and I know it's a very tricky part of this. I guess in the case of my constituent, they fled another country to the United States. And obviously we know where the U.S. Judicial system is imperfect, in some other countries there's not even a judicial system that addresses domestic violence or takes it as a crime. So how would that work in the case where you're fleeing from a country like that to the United States?
The judge in the United States might be could be put into contact with a judge in the other foreign country to talk through, and will make their ruling based on that discussion, based on what they learn, and based on they're the judge. They can make these decisions.
Okay, thank you. I yield back.
Thank you very much, Ms. Jacobs. Let me ask you briefly, when you talk about a resolved case, we had a case of Bindu Phillips, who was from just north of my district in New Jersey. Her two boys were abducted when they were at the age of 8. The police did a full investigation in the Plainsboro Police Department, and she actually testified at a previous hearing that I've had. And it was criminality all over the place. He ripped off everything, stole everything, left her penniless. And above all, and this is all that mattered to her, abducted their two children, Albert and Alfred. For years, she tried to regain some kind of contact, failed every time. She actually went there and discovered that he had so poisoned those two boys against her. Parental alienation certainly can be defined as a poisoning of a child's mind against the left behind parent. So much so that they didn't want to see her. He lied about those two, about her, Bindu Phillips, and now they've aged out. They're 23, and even one will be coming here to the United States to go to school. He doesn't want to see her. I've never seen a more broken woman. She has a deep faith, and she just prays for her children and even for her husband, despite the fact that he kidnapped her children. And I'm wondering, does that inform, like when we're talking to the Indian leadership, and I even, when Prime Minister Modi was here, I had met with the ambassador, with her, and asked for his intervention, got none. Then when Modi was here, briefly had her talk to him, and we gave him a letter, and nothing happened from that. I find that appalling. When somebody comes and says, here's a true injustice that has happened, and he turns a blind eye the way the Prime Minister did, I have concerns, and we all should. But Bindu Phillips continues to this day to be heartbroken in the extreme, like so many of the left-behind parents, if not all of them. And I'm wondering how that is looked at. I mean, when you talk to the Indian government, please bring up her case. Because when she went over there, even some of the in-laws were talking about taking legal action against her. She is the most gentle, empathetic, kind-hearted woman you could ever meet, who just loved her children and loved her husband. She was broken by that too. She never saw that coming. So if you could respond to that. And then I have another brief question Today, Kyle O'Malley, who is also a resident of New Jersey, is filing another appeal in Brazil in his Hague case to return his 2.5-year-old daughter, Gia, to her place of habitual residence, which is New Jersey. He has won in one court in Brazil, then got a mixed review in a second, and now he's appealing it to the third. What's troubling, it's all troubling, but what's an egregious, I think, manifestation of a judge's viewpoint, two of the judges, in their statements explaining their decision against his case, said that they believe that the Hague is outdated. It's an outdated method for resolving international parental-child abduction cases and does not apply anymore. These are two judges making these statements in Brazil. Have you had any discussions with the Central Authority in Brazil about Kyle O'Malley and his daughter, and what can be done to remedy that malpractice on the part of those judges?
So on your first point, I think Ms. Phillips' case definitely underscores the pain, the suffering, the trauma that not just parents, but their extended families, their communities face in these cases. Before I meet with foreign government officials, I very often, with support from my colleagues in the Office of Children's Issues, meet with some of the left behind parents and then raise the cases with the government as examples of the problems that not just one or two parents are facing, but any parent who has a child taken to that country has experienced. Because I think it's so important that my government interlocutors in foreign countries understand the human cost, the human suffering that is incurred by these cases. So that is something that I try to do on a routine basis. And yes, I raise any case that demonstrates the systemic problems in a country, because I think that's important, to put a human face on it. As far as Kyle O'Malley, I'm afraid I'm not intimately familiar with this case. I'd be happy to discuss it with your office to see where we're going. I am dismayed that two judges have reportedly said that this does not apply or that the convention is outdated. Clearly, we have more work to do in Brazil.
Just one follow-up. We do know, I guess, on a brighter, hopefully more optimistic note, that the number of international parental child abductions has declined over the last decade. I just want to ask you about the Children's Passport Issuance Alert Program, and whether that has been something that has markedly contributed to the prevention of abductions.
We certainly like to think it has. We believe it has. The Children's Passport Issuance Alert Program is one way that a parent can flag their child's name in our system, so that if anyone, the other parent or somebody else, applies for a passport, it puts a hold on that processing, that application, so that we can look at who has legitimate rights to apply for that child's passport. It doesn't necessarily prevent the issuance of a passport, but it puts a hold on it so we can examine the custody orders, who has the legitimate permission to apply for that child's passport. And if the applying passport doesn't have it, then obviously the passport, because of our two-parent signature requirement, it plays into that. That if one parent has not given their consent and doesn't plan to, then that passport will not be issued.
Assuming the child has a passport, will that flag that a parent might put on to the system be in operation when the other parent tries to remove the child from the country?
No, because if the passport has already been issued, it will not stop the child from departing, which is why we very much appreciate the Goldman Act's creation of the Prevent Abduction Program. This is where we can stop abductions from happening. A parent can enter their custody order with us. We share that with Customs and Border Protection. The child's information goes into the database, and they can then be stopped at the airport if they're trying to leave through an airport port of entry. This makes a difference. In any given year, we enter about 200 plus children's names into that program, and that does make a difference. I read every day, every morning, we get the overnight duty report, and part of that is the report from our prevention officers as to the number of phone calls they fielded from parents, but also calls from local law enforcement wanting to know whether a child can leave or if there's something going on, as well as from the ports of entry. We have 2 officers who sit out at the National Targeting Center and work side by side with Customs and Border Protection to try to make those, to stop those abductions from happening in the first place.
Are there behaviors that the officers are taught to look for in case there isn't a custody order that's been put on file? Are there behaviors that they are taught to look for?
I would defer to my colleagues in Homeland Security on
Understood.
that.
Thank you. I had a feeling I was a little far with that. Thank you.
Just one, I have a lot of other questions which I'll submit for the record, but just one final with, as you know, Jeffrey Morehouse is testifying, and he has done an amazing job for everyone else, but still has not been able to secure even visitation for his son Mochi. 2010, his beloved son was abducted to Japan. We have a situation in Japan. We have a situation where, he has won court cases. One of them was in 2010, 14, and 2017. He still has no access. Can you prioritize his case as one, because he's such a tremendous advocate for everyone else, including himself, his own son. But it seems to me Japan's got to resolve this. I mean, talk about egregious case, if you could speak to that.
I fully share your appreciation for all that Mr. Morehouse does on behalf of left behind parents around the world, and with a special focus on Japan. And we appreciate working with him on these issues. Again, one of the things that we do when a child who has been abducted to Japan becomes an adult, reaches age 18 or older, at age 18, we seek to contact them, to send them a letter, to let them know that they are now an adult U.S. citizen with the benefits of being a citizen, and we also try to put them in touch with their left behind parent so that we offer to facilitate that communication. In some instances, it's very difficult to locate the individual. We do our best efforts to send those messages as many places as possible in hopes of reaching them. But ultimately, once the person, as you mentioned, parental alienation and the fact that often these children have had no contact with their left behind parent for so many years. And while some are eager and interested at that point in maintaining, in establishing contact, others, it's hard because they have been told all sorts of things. So we try to do, we do that in every case in Japan where a child reaches the age of 18 and becomes an adult.
But thank you. If you could really prioritize this case, because how many times have you testified, even here, Jeffrey? He's been at the United Nations. He's been all over the world, and has met with Japanese interlocutors as well. And I've raised this case. I went to Japan, raised this case, and it's like I get blank stares. And it's just, justice delayed. This isn't even delayed. This is denied. So please. Okay, thank you. I'd like to now thank you for your testimony and look forward to working with you going forward. And for that meeting in August, look forward to it.
Thank you.
Appreciate it.
Thank you very much.
Thank you very much. I'd like to now welcome our second panel to the witness table, beginning first with very distinguished witnesses, including Jeffrey Morehouse. He's an award-winning filmmaker and volunteers much of his time as executive director of Bring Abducted Children Home. Bring Abducted Children Home is a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan. He also strives to end Japan's human rights violations of denying children unfettered access to both parents. Bring Abducted Children Home works to increase public awareness through outreach on the crisis of abduction. He collaborates with an alliance of international partners working to end abduction And I mentioned a moment ago, and he has been, tenacious in arguing for access and hopefully to reclaim custody of his child, Mochi. But he works for everyone else too, in such a selfless way. And Jeffrey, I want to thank you for that leadership. It is extraordinary. As I mentioned a moment ago, you've brought this message everywhere, including to the United Nations, frequently to try to get them to put more of an oar into the water to get more done. Thank you. We then will hear from Dr. Noelle Hunter, who is Clinical Assistant Professor of Political Science at the University of Alabama in Huntsville, Department of Philosophy and Political Science, where she teaches courses on U.S. government, public policy, and international relations. She is the founder and director of the International Child Abduction Prevention and Research Office at the University of in Alabama in Huntsville. It advances data-informed solutions to the global problem of international parental child abduction. It's an interdisciplinary research and practice initiative to improve prevention, response, and resolution. Dr. Noelle Hunter is also co-founder and president emeritus of the I Stand Parent Network Incorporated. That's when I first met her, a non-government organization that empowers parents to recover their children from international parental child abduction and advocates for public policy reform to prevent and end this crime against children and against families. Dr. Hunter co-founded, like I said, the I Stand Parent Network and recovered her daughter successfully from abduction to Mali in the year 2014. We will then hear from Ms. Patricia Appy, who has been partner in the Paris, Appy, and Reese since 1996, a professional corporation specializing in the practice of family law in New Jersey. Ms. Appy's area of expertise is in complex international interstate family litigation. Ms. Appy has litigated, been qualified as an expert witness, and consulted on international family disputes throughout the world in many places, including Pakistan, where it is a very, very challenging place to be in that court. She frequently consults and is regularly qualified as an expert on issues related to application of religiously based family law systems. She speaks throughout the United States on family dispute resolution in both Hague and non-Hague countries, and in assessing risk factors for international child abduction. She has also conducted over 1,000 hours of continuing legal education for the Judge Advocate General Corps and for our armed services. And I would just point out, when we have worked on a number of military service members who have had their children abducted, it was Patricia Appy who led the way, not only with the Pentagon, but also with Congress in showing the way and forward when bad advice was being tendered by JAGs, which led to worsening the situation. She has been a leader in educating the military on this. And I would just say finally, when we wrote the Sean and David Goldman International Child Abduction and Prevention Act, and it took 5 years, as I mentioned a moment ago, to finally get enacted into law. Passed the House twice, sat in the Senate and languished. We finally got into law. The person who provided unbelievable expert insight as to what we should include to make the difference was Patricia Appy. So thank you for that. And she's working with us on our new bill. So thank you. Mr. Morehouse.
Thank you, Chairman Smith, Ranking Member Wild, and the committee for inviting me here today to share my personal experience and my expertise on the ongoing crisis and crime of international parental child abduction. I also want to acknowledge all of the parents and supporters that showed up in person today at the hearing, as well as our partners internationally that are watching this live all around the world with a specific focus on Japan. Bring Abducted Children Home is a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan, and strives to end Japan's human rights violation of denying parents unfettered access to their children and children to their parents. We also work with other organizations on the larger goal of resolving international parental child abduction worldwide. I'm a founding partner in the Coalition to End International Parental Child Abduction, along with Dr. Noelle Hunter and other partners, including one that's here in the room today, uniting organizations to work passionately to end international parental kidnapping of children through advocacy and public policy reform. Internationally, I collaborate with an alliance of representatives and organizations in Australia, Canada, France, Germany, Italy, Japan, the United Kingdom, and the United States, working together to end parental child abduction to and within Japan. According to the U.S. government, there have been more than 500 U.S. children kidnapped to Japan since 1994. Japan is internationally known as a black hole for child abduction. A signatory to the Hague Abduction Convention since 2014, Japan betrays its obligation to return victims and guarantee rights of access. As a senior Embassy of Japan official informed me in a May 2018 meeting, they leave it up to the kidnapping parent. It's estimated that 150,000 children per year and 3 million over 20 years are victims of loss of access to a parent in Japan. This would include American parents living there who continue to be robbed of parental rights by Japan's single custody laws. The UN Convention on the Rights of the Child states children have the right to maintain a relationship and direct and regular contact with both parents. Japan fails to honor this, and they are a signatory of this convention. Last year on October 13th, I briefed the UN Human Rights Committee in Geneva, highlighting key points from our multinational, multi-NGO report, emphasizing the traumatic impact on abducted children and parents, and called on the committee to end the ongoing suffering, hold the government of Japan accountable. In their concluding observations, the committee, they wrote, "The committee is concerned by reports received regarding frequent cases of parental child abduction, domestic and international, and the lack of adequate response by the state party, Japan." The Goldman Act was signed into law 9 years ago in August 2014. Since then, there have been at least 10 hearings, and I think I've attended all of them, to get the State Department on board with holding foreign governments accountable and increasing reunifications and returns. They've demonstrated through 3 administrations little true commitment to do this. 23-year-old General Accounting Office reports on international parental child abduction shockingly illustrate the same entrenched resistance. On December 2nd, 2009, former Assistant Secretary Bernard Aronson testified to the Tom Lantos Human Rights Commission hearing. Chairman Smith, I think, was chairman at that point, too, in that hearing. And he said, and I'm going to quote his exact words, "The current system to secure the return of these abducted American children does not work and will not work unless it's changed profoundly. I don't doubt the sincerity or the dedication of the professionals at the State Department who have led in the responsibility for this problem, but they do not have the tools or the power to do their job effectively. And unless Congress gives them the power and tools, we will be back here in 5 years or 10 years with another set of hearing and another group of parents with broken hearts and devastated dreams, and we'll be making the same statements that we are making here today," end quote. Congress provided these tools in 2014. They were not used as intended. Now is the time to enhance them and be prescriptive with how they are used. Empower the Office of Children's Issues to be more effective in addressing international parental child abduction. Establish a presidentially appointed, Senate-confirmed ambassador at large to monitor and combat child abductions who reports directly to the Secretary of State. Standardize the process of making welfare and whereabouts visits requests so the process continues automatically and persistently every 3 months after the initial request until the non-abducting parent requests in writing for it to stop. Require the Office of Children's Issues to work in close liaison with the Department of Justice to enhance a whole of government response instead of agencies and departments cocooned in silos. Expand the annual reporting on international parental child abduction to include a full accounting for all kidnapped children, not just open cases. This is vital. As noted in their annual report, the Department of State considers a case resolved and, quote, closed for the following reasons. A judicial or administrative authority has complied with the convention and determined not to return the child under the provisions of the convention. And I'll just comment on that. It's interpretive. The Hague Convention is an interpretive agreement. There's no international body that punishes countries for failing to uphold the basic terms and agreements of the Hague Abduction Convention. So it's interpretive when these foreign countries create these judicial rulings to not return kidnapped U.S. children. Second reason they close these cases and consider them resolved. Parents reach a voluntary arrangement for the child to remain. As the chairman mentioned, there's considerable pressure on parents with these cases as they go on. So we don't know if this is a pure reason that the case is resolved and closed, but it's closed in the report. We need to understand why these cases are closed. It will illuminate and illustrate real patterns with countries. The third reason they'll close cases, the left behind parent withdrew the application or request. Now, there may be legitimate reasons for that. There can also be a lot of pressure. I know cases in Japan where there's intense pressure for parents to withdraw their application. And they're dangled with a carrot, baited that they'll get some sort of judicial process that turns out to be not enforceable. And this is common in other countries as well. But we need to know why these cases are being closed. 4, the left behind parent could not be located by Children's Issues for more than a year. This one's always been puzzling to me. Now, I know a lot of parents. I've been doing this for, unfortunately, 13 years. And I know Dr. Hunter knows a lot of parents too. I also know a lot of parents that don't know who the heck their country officer is anymore. They know me, as Ms. Bernier-Toth mentioned, because I engage with them frequently. But a lot of parents don't know. So we need to know, you need to know, when cases are being closed because there hasn't been communication. Because I can assure you, 99.9% of parents still want to know where their children are. They want response and action. So maybe there needs to be a better effort to locate them if they are closing a case for this reason. But let's see the data on this. And lastly, when a left behind parent or child passes away. Now this does happen. I know of 2 cases. I know of a case where a kidnapping parent is deceased, 2 actually, and I know one where the left behind parent unfortunately passed away. But I would still think it's very informative to disaggregate this information so Congress and the American public can understand what's actually going on here when cases are resolved. Additionally, cases are closed when the victim reaches 18. Now, we don't do that when stranger abduction occurs, do we? We don't just suddenly say, well, they're 18, wherever they are, we'll just forget about them. Why are exceptions made for victims of international parental child abduction? When an abduction case is closed without the child being returned, as I said, it's essential to know why. This is going to create a clearer picture of the IPCA crisis with each country and a more useful tool in prevention cases in family courts considering travel restraints. I just respond to something briefly that Representative McCormick asked a question of the previous panelist on the worst offenders. And I didn't quite hear a clear response to his question, so I'll just reiterate what one of her predecessors, Ambassador Susan Jacobs, said in a hearing in this committee in 2015. She was asked the very same question, and she responded without hesitation. The top 3 worst offenders are Brazil, India, and Japan. Her words. So this is going to create a clearer picture of the IPA crisis with each country, a more useful tool in prevention cases in family courts considering these travel restraints that are essential to get children into the Prevent Abduction program. Somebody mentioned and asked about the Child Passport Issuance Alert Program. That's an interesting and valuable tool. The Prevent Abduction program is even more valuable and important, but it requires a travel restraint order from a court. One of the problems that I see, and I serve as an expert witness in prevention cases, and Patricia Appy is an attorney, an expert in this area, and she can speak to this probably more, but I have to spend time explaining to the court the numerous reasons why the State Department resolves a case without the child being returned. If you disaggregate these numbers, it will be very clear. And a couple of you mentioned you were former attorneys or practicing attorneys. It will be very clear in the numbers that children are not coming back from these countries. That will then help with prevention so that we don't have to spend time explaining to the court what this report really says. The way the reports are written often give a false impression that the kidnapped child will come home, that the parent can rely on the Hague Abduction Convention, a bilateral agreement, or respect for a U.S. court order and our laws. It gets misinterpreted that if a country is not placed on the non-compliant list, that they are compliant. A tiered report with disaggregated data modeled after the Trafficking in Persons report, or TIP report, will help address prevention concerns, and if used with correct intent, may provide incentives for foreign countries to make changes. Certainly the State Department wants to prevent future abductions, so they ought to be more than willing to provide this information. We worked extensively to try and get them to release data, and a couple of years ago they did publish the number of cases outgoing from the US and the number returned by year. But they were unwilling to disaggregate the data that we are asking for now. So we know that's coming. You mentioned pending legislation, and appreciate that. So the next point I want to get across is, require the State Department to use multiple tools that are already in the Goldman Act. Hearing after hearing, this has been addressed both in the Senate and the House in 2018 in particular, and they've declined again. They are entrenched in using démarches for countries who fail to repatriate and reunite us with our children. State views démarches as important and meaningful when year after year they fail to move beyond them and foreign countries still don't improve. But clearly, démarches alone are about as valuable as junk mail. Let's move beyond them and use substantive tools. In the Senate's annual resolution countering International Parental Child Abduction Month, they again noted the Supreme Court of the United States has recognized that family abduction is a form of child abuse with potentially devastating consequences for a child, which may include negative impacts on the physical and mental and well-being of the child, and may cause the child to experience a loss of community and stability, leading to loneliness, anger, and fear of abandonment. Our cases are not custody disputes. The impact from this crime on the victims is lifelong. In last week's article in The Age by journalist Eric Bagshaw, who's written multiple times on this issue, Susumi Wataya bravely shared his experience. He says he was beaten when he asked about his father. Then his last name was secretly changed, cutting him off from all future contact. I lost my identity, he said. The pain that this Japanese system causes children is beyond description. Our coalition leadership has met with stakeholders in the Department of Justice and the FBI many, many times. One consistent point that we all agree on is the sentencing guideline under 18 U.S.C. 1204, the International Parental Kidnapping Crime Act, should be higher in order for this crime to be taken more seriously. The sentencing guideline for a stranger abduction is up to 20 years. It's a moderate and reasonable change to increase it under this statute from 3 to 10 years for, and this is quoting from the statute, whoever removes a child from the United States or attempts to do so, or retains a child who has been in the United States, outside of the United States, with the intent to obstruct the lawful exercise of parental rights. Currently, the criminal statute excludes 16 and 17-year-olds. In contrast, most states set the age of majority at 18. It's moderate and reasonable to amend this to define a child as a person who has not yet attained the age of 18. Existing federal law and the Department of Justice guidelines for missing persons to be entered and maintained into the National Crime Information Center, or NCIC, database are routinely disregarded by local, state, and federal law enforcement. Parents can be ignored completely or incorrectly informed that they need a criminal charge or a custody order. If they're lucky enough to get a response that leads to an entry into the NCIC, an officer or an agent in the future who inherits the case might decide just to remove it without the child ever being located. The National Center for Missing and Exploited Children has acknowledged this, that cases are routinely removed without the missing persons being located. And talking to our friends from the State Department before the hearing, they also said, yes, they see the same thing. Now, starting with this past summer, I spent 10 months going back and forth with a detective in the Seattle area who inherited my case, who decided that my son was no longer missing when he turned 18. He somehow magically had free will, even though he had spent the past 13 years being kidnapped. So he removed him from this database. This meant that NCMEC, the National Center for Missing and Exploited Children, also had to remove his missing persons poster, taking away a valuable, valuable tool to try and locate my son and reunite. I shared with this detective the requirements under federal law and Department of Justice guidelines. One of NCMEC's attorneys spoke with the officer to offer technical guidance. I engaged an FBI agent at the Violent Crimes Against Children unit, who I know, and a staff member at the Amber Alert Training and Technical Assistance Program for their views. We all agreed. We're all on the same page. This is what should have been done, but not this detective. How many times has it been repeated across America where parents of internationally kidnapped children are not receiving this bare minimum required under federal law assistance? The solution is simple and in alignment with the stakeholders. Require the FBI to enter each case of a missing child into the National Crime Information Center database, and each missing person who has been removed but not located should be re-entered. The Interpol yellow notices identifying my son as a missing person was also removed by the FBI and from the office in Seattle, although he remains missing. Let's fix this too. Require the FBI to enter or re-enter and maintain each case with an Interpol yellow notice. Victims of IPCA should remain in both the NCIC and Interpol until they are returned, or after reaching the age of 21, request their removal in person to a U.S. consular official or federal law enforcement officer. Mandating the FBI to provide these tools will help victims better understand what has occurred to them and the resources and rights that they are entitled to as American citizens. Now, I was reminded of this in January of this year when a victim contacted us, insisting they had never been kidnapped. This was a State Department verified case. but it was this person's belief, because that's what the abductor taught them. If a parent is able to locate and maintain first contact, hopefully it goes well, but so often it doesn't. Reunification staff at National Center for Missing and Exploited Children has previously shared with us that most IPCA victims are taught by their kidnappers that the other parent doesn't want them, they're dangerous and harmful, they're dead, or that the other parent is unknown. Maintaining the NCIC entry and Interpol yellow notices will be useful tools in aiding authorities to support parents in locating and reuniting with their missing children. Do we want to be back here in a year? In 5 years? In 10? Discussing what needs to be done? We know what needs to be done. Amend these laws. Let's do this.
Thank you so very much. For the record, we have incorporated your recommendations into our draft bill, and I can't thank you enough. All three of you have provided unbelievably incisive insights for us as to what needs to be done. So your testimony and your words, your wisdom has not gone unacted upon. So we will push this hard to try to get it enacted into law. So I thank you.
Thank you, Mr.
Hunter.
Chairman.
Dr. Hunter.
Good afternoon, and thank you, Mr. Chairman. Thank you for the opportunity to come again before this distinguished committee. I'd like to request that my statement be entered into the congressional record in full. Thank you, sir. Mr. Chairman, Ranking Member Wild, and members of this distinguished committee, in the decades since my own daughter's abduction and return, I have had the privilege to be a voice for victimized children and families. I have felt this weighty privilege of speaking for so many parents who have looked to you, Mr. Chairman, looked to Congress for leadership and oversight to require the State Department, the Justice Department, the Department of Homeland Security, and all of their respective agencies that my colleague spoke of who are charged with this issue to enforce the laws concerning international parental-child abduction, kidnapping, and wrongful retention of American children held abroad. And Mr. Chairman, I would just like to point out, as we can all see, that the State Department left this meeting immediately after the testimony of the special advisor. This is their standard practice, and it transmits a message to us about priorities in word and in deed, and I would just like to mention that. I am the director of the International Parental Child Abduction Research and Prevention Office at the University of Alabama in Huntsville. And Mr. Chairman, if I can just say, the title of that office is a direct acclamation to you and to the work that you've done on this issue. We thought very carefully about what we would call this office, and it's not coincidental that ICAPRO, the name of this office, is a reflection of ICAPRA, the Goldman Act that you wrote, authored, and shepherded to passage and are still seeking the robust implementation of. And so I honor you, sir. I thank you so much for that. And I want you to know that as I've been working on this issue now for 10 years, while my daughter was abducted and came home and has come home, you have been a beacon for us. And at the times when I was tempted to just go on about our lives because my daughter is home, it was your work, my dear colleague and friend Jeffrey's work, and importantly, these children that kept me going. And I would like to say that there are 2 returned children in the office, are in this chamber today. I see Miyu and Amani in the back, my dear girls who will be joining us for a survivor camp that my organization hosts, because once the children do come home, they still need help. They still need resources. And so it is in that sense and in that vein that I also represent I Stand Parent Network. I Stand empowers parents to return their children from international parental abduction and advocates for legal and public policy reform to prevent and end this awful crime against children and families. And one more thing about ICAPRO before I move into my formal remarks. This is the first university-based enterprise to drive research and data-driven solutions to the problem of international parental child abduction. There's not another entity like this that exists, and we look forward to working with Congress to provide different perspective, research, and data-driven information that can help ameliorate this problem. I am a survivor, sir, and like my brave and beautiful daughter, Muna, who on Christmas Day of 2011 was kidnapped by her father from Moorhead, Kentucky to Mali, West Africa, when she was only 4 years old. Now, despite some initial delays, Mr. Chairman, I soon had a court order for her return, cases with the FBI, the Department of State's Office of Children's Issues, the National Center for Missing and Exploited Children, and local and state cooperation as well. In the Office of Children's Issues, I had frequent communications with my country officer. I had a great country officer, and a working relationship with the embassy personnel in Bamako. This is very rare, but it ought not be. This ought to be standard practice, and I appreciated the question earlier about what can be, by the ranking member, what can be done to empower consulars and embassies abroad. There is so much more that can be done there. I do work closely with members of Congress in my own case I did work closely with members of Congress in my own case, Senator Rand Paul, and especially my beloved Senator, Minority Leader Mitch McConnell, and your colleague, Representative Hal Rogers. The latter two stood shoulder to shoulder with me in a creative pressure campaign for nearly 3 years, both directly engaged with the State Department, the FBI, and even high-ranking officials in the Mali government. It was very clear, Mr. Chairman, to people on 2 continents that this Kentucky delegation was serious about its constituents' well-being and her need to be home. I was reunited with my daughter on July 11, 2014, in which can only be described as a whole-of-government approach, which is why she's currently home, and this week she's completing her last week of high school freshman year. Every entity that could be mobilized for my daughter was, and we work cooperatively. Why can't that be the case for other children, sir? Our government has the resources, it has the capacity. What we have to overcome is the bureaucratic discretion and the differential prioritization of resources. What could possibly be more important than America's stolen children? Unfortunately, my family's experience is rare, and it should not be. This nation, as I indicated, has systems, structures, resources, and international standing to repatriate U.S. children and to hold nations accountable until they comply in releasing America's stolen children. Now, I've recently come to know my fellow parent, John Sitchie. John's 2 children were abducted from San Francisco to South Korea in 2019 and have yet to be returned to California. They were both toddlers at the time of the abduction. His son wasn't quite 3 years old, and his daughter had just turned 1. Babies. Despite receiving a finalized Korean Supreme Court Hague return order in February 2022, he hasn't been permitted to see his children at all. He's been cut off from them, and as was indicated by my colleague, the lifelong emotional damage is being done day by day. It's intense. Since last October, John has staged a public protest in Seoul, walking for hours and hours on a portable treadmill, demonstrating the plight of every left-behind parent who is trying to reach their children, doing everything they can but getting nowhere. There's a picture of John on his treadmill in the galley today. Even the Korean public and media are sympathetic and supportive of his quest. Yet the Korean government has shown little regard for the Hague return order or his daily demonstrations for his children. Our nation has twice cited this Hague partner, Korea, for noncompliance, including this year. What I find remarkable and inspiring is that John has walked nearly 600 kilometers on this treadmill, and people often ask him how he keeps going day after day. Sir, his answer is always the same. How could he give up on his children when they need his help? This is indeed the question that parents of internationally kidnapped children ask and answer every day. The impact of Mr. Sitchie's visceral metaphor cannot be understated. I hope we're all now thinking about John and all the parents who were on this treadmill, exerting all of their heart, energy, time, money, and resources without their children coming home. And when I first learned of John's story, I was filled with admiration for this arduous and loving tribute for his abducted children. That admiration quickly gave way to sorrow, empathy, and frustration. John Sitchie's treadmill experience embodies those of too many other parents and stands in stark contrast with my whole-of-government approach leading to my daughter's return. But I'm not the only one, Mr. Chairman. Alyssa Zagaris is in the audience today. Alyssa returned her son Leo home from wrongful retention in Greece in 2013, in March of 2013, after 20 months of alienation and separation. Through her fierce devotion, an unrelenting action, and importantly, a strong governmental response. Alyssa is also a co-founder of I Stand Parent Network. By contrast, sitting near Alyssa is Samina Rahman and her son Abdallah. Mr. Chairman, this is a special day in this chamber, because this is the first time that Alyssa and Jeffrey and I and longtime advocates have met Abdallah. You see, Samina was on this treadmill for 9.5 years. She's been with I Stand since the beginning. From April 2013 to December 2023, she was on the treadmill while the United States and India traded hollow niceties about resolving abductions. Over nearly a decade, she watched India get pass after pass, démarche after hollow démarche, and watched that nation race to the top unfettered race to the top 5 rankings for destination countries of abduction. She had to watch from the United States as her small boy grew into a teen as he missed years of school. And most tragically, she had to watch her father pass away without ever seeing the grandson he helped to raise until his abduction. In the end, as was mentioned earlier, Abdallah is home through a voluntary return, not through the hundreds of thousands of dollars this mother has expended in U.S. and Indian courts, not through the scam with she and other parents, including another one in this courtroom, the scam that built her out of precious resources by someone who knew exactly how to exploit these loopholes in U.S. government. In the still fragmented post-Goldman Act inefficiencies in our U.S. systems, knew exactly how to exploit those, and certainly and regrettably not through the help of her own government. Samina is sitting here today with her son because of her indefatigable mother's love, her sheer fortitude, her resource capacity, and because she, like many other parents, were moved to do whatever is necessary. How many other children yearn to be with their parent, but whose parents don't have similar means, support, or the wherewithal to sustain their case through costly engagements with 2 or more governments, language barriers, and fragmented or non-existent governmental responses. Mr. Chairman, before I offer recommendations for improving federal performance to aid victimized American children and their families, there's one more experience of a parent that I'd like to relate. Astrid Johnson is sitting with me today. She is here in the audience, and she's on the treadmill. She's on the proverbial treadmill. In August 2021, Astrid's missing angels, Charlotte and Georgia, were abducted to and remain in Dubai by their father, who's, by the way, who is not a resident of Dubai. He is Australian, and used that opportunity to take them to a country where he believed that he could abscond and retain these children unlawfully from their mother. Astrid has done everything that she can, expending her resources, obtaining an international kidnapping warrant, achieving favorable rulings in Dubai. The Dubai courts rejected the father's unfounded custody petitions and further ruled that it had no jurisdiction in the case. It's my understanding that federal marshals are standing by, ready to travel and execute that warrant. Her congresswoman was here a little bit earlier, Representative Jacobs, and if I could speak to her, and perhaps Ms. Johnson can speak to her while we are here, I'm very, very clear that one of the reasons that my daughter is home is the full court press of my congressional delegation. You know that, sir. You certainly do. You remember Senator McConnell and Chairman Rogers and Senator Paul. They went to bat for my daughter, and Molly sent her home because all 3 of them began to intimate that they were going to move beyond a public statement and cast their eyes towards the United States' largesse, governmental largesse toward those nations. Put my baby on a plane and send him home. Same with David Goldman. Why can't that still happen now? This is what I want to convey to her representative and to her delegation and to all of the representatives here. Congress has the power of the purse, it has the gravitas, and it has the onus and the impetus to act justly for America's stolen children. Even with the mechanisms in place for Ms. Johnson, the pace of federal action and response to reunite her and her children has been too slow. Time, as you said, sir, so accurately, is the #1 enemy of internationally abducted children. And as her case indicates, inaction or slow action by the very entities charged with assisting this vulnerable population is enemy #2. And I discovered this morning at 3 a.m., Mr. Chairman, I discovered I'm on the treadmill with Astrid. At 3 a.m. this morning, we had a call with the court in Abu Dhabi. Now, I mentioned Dubai earlier because that's where the father attempted to unlawfully exert a false custody position. When Dubai turned him down, he shopped and went right down to Abu Dhabi. We're on the phone at 3 a.m. on the treadmill for her to have to continue to spend her money and her resources to accomplish something that should have already been settled and should already have been home. I don't mind being on the treadmill with you, but we need to get off. And the way that we're going to get off is for our government to hold nations accountable through the State Department, and that means holding the State Department accountable. It's time for resolute action by our government to bring these children home. It's time for the State Department to act on the UAE's twice cited noncompliance, including in the resolution that my colleague mentioned earlier, the Senate resolution. It's time for UAE to reject the father's form shopping and fake travel ban requests. It's time for the United States to stand with Astrid Johnson to bring Georgia and Charlotte home. When the Goldman Act was enacted into law in 2014, we had tempered expectations for its full and aggressive implementation. Over the past 9 years, however, even our most measured expectations for the State Department to fulfill its mandates have been disappointed. Instead, our children remain kidnapped to foreign nations, separated from their seeking parents and extended families, and parents remain on John Sitchie's treadmill, driven by a love for their children and a hope that our government will be true to what it says on paper. That's a quote from Dr. King, by the way. Mr. Chairman, it's time now to amend the Goldman Act to bring abducted children home. I respectfully offer the following recommendations to improve federal response, prevent abductions, and reunite children with loving families. First, give Congress greater authority and oversight capabilities to respond to and aid constituent requests. This speaks to the notification. We were privileged, my colleague and I, to have a briefing with Foreign Affairs Committee staffers a few weeks ago, and I posed the question to them about how frequent or how aware they are of the notifications that come to state that Ms. Bernier Toth said there weren't many. Now, that doesn't mean the information didn't come to them, but at what priority? And so the State Department complies by letter of the law by sending these written notifications to member of Congress as required by the Goldman Act, but that privacy waiver is a challenge for us, and I know parents in the audience have attempted to overcome this challenge. So if a parent does not sign a privacy waiver, it may mean that that information doesn't get to their member of Congress. And even if the privacy waiver needs to be in place and stay in place, the State Department should still be requiring information, should be reporting on all the information necessary. Numerica data can be shared about how many constituents have reached out to the State Department. That information can be shared. Recommendation number 2, sir, and this speaks directly to the stand-up of ICAPRO at the University of Alabama in Huntsville. Fund the research. Congress must fund the research on international parental child abduction so that we can understand government performance and its impact on children and families. The testimony of the State Department today and over time makes clear the necessity of independent research. As a political scientist, I'm keenly aware of bureaucratic discretion and the way in which variation in case management has occurred in this agency. I was also puzzled by the special advisor's comments early on in which she said something to the effect that, I know some think that withholding aid is the way to go. Respectfully, sir, it doesn't matter what we think. It doesn't matter what Congress thinks. The law says that there are escalating actions that must be taken beyond the demarche. And so research will allow, funded research will allow the performance of the State Department to emerge in view. And that's how Congress can fully exert its oversight capacity. The existing research is fairly limited, because the information we're getting is coming from the State Department, who has a vested interest in minimizing the extent of the problem and controlling the narrative. Independent research is necessary, and Congress must fund that. Recommendation number 3, fund training against relevant sectors to effectively educate and prepare responders, the legal community, and other relevant actors to consistently uphold the law concerning internationally kidnapped children and victimized families. I respect what the special advisor said earlier about the trainings that are occurring. What I don't know, and what Congress doesn't know, is the frequency, the consistency, and how well that training is landing. But I'm not sure we can make those decisions or understand how well that training that they bragged about is going without some sort of performance reporting. The annual report does not really, beyond, a superficial discussion, doesn't really talk about that training, who, what, when, where, and why. That is a need for research, and that's a need for funded research. And finally, help parents wage and win this costly battle to reunite with their victimized internationally kidnapped children by amending the Victims of Crime Act to include international parental child abduction and make legal expenses for the Crime Victims Fund available for parents in attempting to repatriate their children. I was fortunate to not have to expend as much money, although my cost was high, in the thousands of dollars. I sit next to a colleague, I sit among parents who have spent hundreds of thousands of dollars. If the Crime Victim Act is available for children who have been domestically abducted, why not for internationally abducted children, arguably, whose parents would need those resources more? Now, in closing, I met a new parent today on the treadmill. Gabriel is here, Caleb Gertner is here. His children, Gabriel, Gideon, and Lydia, were abducted to Belize in 2018. I want to be on the treadmill with him, but we don't want to be on here indefinitely. We need to move forward. Jocelyn Goyle is here. She is the grandmother of a reunited daughter, and they went to considerable lengths, often in direct opposition to our government, to return their daughter. John Stefanik is here, and his daughter Camille has been abducted to Costa Rica, and I am appalled by Costa Rica's behavior in not only protecting and sanctioning the abductor, but creating an environment in which Camille has been subjected to further child abuse on top of the abduction. Vikram Jagtani is here, and his sweet daughter Nikita, he sometimes has contact with, sometimes not. And as I indicated, Miyu and Amani are here, and they're the testament to what can happen when parents work to return their children home. But all of us need you, all of us need Congress, and all of us need the State Department, the Justice Department, and Homeland Security to, again, live up to what it says on paper in the Goldman Act and all of the laws that came before that. Mr. Chairman, I thank you so much. I honor you, and I appreciate the opportunity to speak on behalf of these children.
Dr. Hunter, thank you so very much for your very eloquent testimony. Your recommendations are outstanding, and we are, since you have conveyed this to us before this hearing, many of them, we're incorporating them into our reform bill and our update bill to the Goldman Act, so thank you for that. And for focusing on all these families that are here with their precious children and pictures that they're holding for us to see. It just brings home again this terrible crime, this kidnapping, which leads to parental alienation and just it harms everyone, especially the child, but also in a very egregious way, the left behind parents. So thank you for your leadership. I'd like to now yield the floor to Ms. Patricia Appy.
Chairman Smith, Ranking Member Wild, and distinguished members, I continue to be honored to have been invited to return to offer testimony before the subcommittee to respectfully address my observations and recommendations formed from the perspective as an international legal practitioner. I'm testifying in support of enhancing the protections provided against the scourge of international child abduction and in providing assistance in the prompt repatriation of children and the restoration of families devastated by parental abduction. I intend to offer my observations, including referencing legislative proposed amendments to the Sean and David Goldman International Parental Kidnapping Prevention and Return Act. I am stunned at the length of time it has been since we have reviewed and evaluated whether or not there need to be revisions that reflect the world that we are in now and the circumstances that we have seen historically in the work of our government in addressing these issues. I've provided a summary of my anticipated testimony and would respectfully request that it be included in the official record. At the close of 2022 and early in 2023, two events transpired which have had a significant impact upon the way child abduction is viewed and addressed under international law as a global human rights issue. And I would propose that both of these examples demonstrate the necessity and importance of the proposed amendments, which are being considered and hopefully will be enacted. On March 17th, 2023, the International Criminal Court issued arrest warrants against the President of the Russian Federation, Vladimir Putin, and the Presidential Commissioner for Children's Rights, Maria Lvova-Belova, for the war crime of the wrongful deportation of children from occupied areas of Ukraine to the Russian Federation. Certainly, the world could not have been surprised by the call to accountability of the Russian Federation in the events taking place in Ukraine. And indeed, you were one of the first before this Congress to reference the need to seek that accountability. However, the selection of the abduction of Ukrainian children as the identified criminal action both elevated and solidified a recognition of child abduction for the traumatizing, abusive action that it genuinely is. Further, a careful review of the diplomatic declarations filed with the Hague Conference on Private International Law, pursuant to the reciprocal treaty obligations of the Federation and Ukraine, pursuant to the convention, demonstrated that the Russian Federation, which acceded to this convention in 2011, was already signaling its intention as early as July 19th of 2016 to ignore protestations by Ukraine regarding the applicability of the treaty within the area it had occupied, and to treat any allegations of international child abduction within the occupied territories as purely domestic issues. President Zelensky last week indicated that over 19,000 Ukrainian children had been abducted by the Russian Federation. The scale of this abduction could not have been accomplished spontaneously. It isn't done with a plan on the back of a napkin. This was an orchestrated event by the same individuals who serve as the oversight for the central authority of the Russian Federation under this treaty. It begs the question of how those in the State Department who are responsible with regard to monitoring the Hague Abduction Convention missed the signal across the bow that this convention would not be honored in those occupied territories. On the other side of the world, on the 12th of December 2022, the Australian government indicated that federal legislation would be enacted to clarify procedural protections for the purpose of ensuring that allegations of family and domestic violence by parents accused of having wrongfully removed or retained their children could be considered as a priority before return orders would be made for children under the Hague Convention. The Australian government described their efforts as providing safeguards to parents and children who assert that they are fleeing family domestic violence when defending applications brought under the convention. Notably, the statute is seen to confirm that a court which has offered a defense to the obligation to return a child does not need to determine that the family violence which has been alleged by the taking parent has actually occurred as a predicate before taking it into account. While the Australian government provided renewed assurances that the legislative enactments did not impact upon its intention to comply with its obligations under the Hague Abduction Convention, among practitioners like myself, there are serious concerns that the Australian legislation may be only the most recent of systemic assaults against the application and effectiveness of the Hague Abduction Convention. There is a growing belief that the prevention of the wrongful removal of children has been rendered more difficult because of the disintegration of the underlying belief that child abduction operates to harm children. As Ranking Member Wild indicated earlier in this hearing, This is an incredibly complicated diplomatic and international legal issue. However, there is a pathway forward. In my estimation, overwhelming benefits are contained in the proposed amendments to 22 U.S.C. 9111 to support efforts to minimize child abduction and provide tools to enhance the ability to return children who have been abducted. I'm going to point out those legislative initiatives I would, as a practitioner in this field for 35 years, identify as particularly important. First, the proposed amendments to the definitions and reporting functions of the Department of State will provide a more concise and understandable basis to evaluate the legitimate state of reciprocity which exists among and between treaty partners. It's important to recognize that how the report is used. It is not just used for congressional oversight. It's used by judges and lawyers daily. It is embedded in statutes, state statutes, which assess risk of wrongful removal and return. As a result, it is incredibly important to judicial deliberation and determinations on parental access and those circumstances. If we do not have the ability to actually understand what the genuine numbers are, what the genuine statistics are, and if we are not all on the same page as to what terms such as voluntary resolution or resolution at all really represent, then the State Department, perhaps in an effort to be diplomatic, are actually misleading our judges and parents rendering decisions and agreements by not providing them genuine information upon which they can rely. In particular, an accurate identification of what constitutes a resolved case has already been discussed in the testimony that you've heard, and will permit a better description and understanding of the obstacles to returning children who are abducted, and give a picture of how many children are actually subject in real time to having been wrongfully removed or retained. The special advisor referenced case notes with regard to judicial determinations which had been made to resolve cases, in answer to your question in evaluating whether or not a judicial determination is actually substantially in conformance with the treaty. I didn't understand the answer. Case law does not require an interpretive summary by the Department of State, and if it's being done, who's doing it? Where would the expertise come from to be able to evaluate a foreign order and indicate whether or not it complies with the treaty? And why would you not then provide a list of cases in individual countries that reflect that there has been a judicial determination that may technically have resolved the case, but in fact bears no relationship to the actual treaty obligations and the reciprocal obligations of the Hague Abduction Convention? I think it's important. I'll give an example that Costa Rica is a country in which their Supreme Court recently declined to apply the convention, establishing as a matter of law that when there is an application by a taking parent for asylum or immigration status protection on behalf of a child, it takes priority over the treaty obligations of the convention. Now, what's really interesting about that is I didn't see it referenced once in the report. I think that's a big deal. And I believe that that issue is going to be raised potentially to the Inter-American Court of Justice. It should be referenced so that judges and lawyers and parents who are addressing whether it's a request for a child to visit Costa Rica or actually addressing a case, know what some of the legal challenges may be. I also listened to your question to the special advisor and the questions that were asked regarding identifying the difficulties in certain countries or addressing the difficulties and the issues of non-compliance. She was reluctant. She was attempting to make excuses, even, as she said, even for the countries that they've identified as non-compliant. And here's the rub. She doesn't represent the left-behind parents. She represents the United States of America. And so she ultimately is going to be acting not as an advocate in the classic sense of that word, but as a representative of the United States government reflecting the diplomatic priorities of the foreign policy of the United States. So here's the problem. There will always be a reluctance to use diplomatic tools that are available in the existing legislation because of the broader necessities. So that's the primary reason I support wholeheartedly the imposition of the tier system, which provides, and we have an ample demonstration in dealing with trafficking, provides an objective mechanism so that any diplomat who is placed in the position of having to evaluate or bring accountability to the actions of a country will be able to say, I know you're working hard, but this is the objective test. This places you in this tier. This is what is required when a country is in that tier. We have over nearly a decade since the original legislation, and there has been almost no use of any of the enumerated sanctions available to the Secretary of State. We haven't even been told what the mechanism is to present to the Secretary the policy considerations and a request in order to address this, the most egregious and systemic violation of human rights. It's clear that the institutional structure of decision and policy making within the Department of State makes it exceedingly difficult to synthesize and formulate a broad diplomatic strategy which unapologetically addresses the impact of child abduction. By constructing a deliberate and objective tiered system, a mechanism to sanction recalcitrant states is created while still preserving diplomatic flexibility and nuance. The amendments proposed addressing issues of family violence actually began as discussions before the Tom Lantos Commission on Human Rights over a decade ago, in which hearings conducted by this body under your leadership heard compelling and scholarly testimony addressing the tension between the International Child Abduction Remedies Act and the complexities of addressing global domestic violence. Unlike Australia's federal legislation, the proposed amendments do not alter the language of ICARA or alter the responsibilities of the central authority that are met under the treaty. These legislation proposed amendments focus on providing objective information and practical assistance with which judges can quickly and effectively evaluate the protections genuinely available for victims of domestic violence in their considerations and deliberations and fashioning of undertakings, which will allow them also to distinguish pretextual arguments from genuine issues of domestic violence. The amendment will better facilitate the ability of a court to refer to objective information and assist it in deliberating and addressing a request for return, fashioning orders for the organization of rights of access. I would note also that the special advisor spoke about judicial communication, and its benefits, I cannot see where, under the existing legal process, there would be a role for judicial communication to serve in addressing the defense raised to a return under the convention. In fact, the most important information for a judge to have would be whether or not there is available in the country from which the child has been removed, whether there is a opportunity for domestic violence protections, and whether or not that can easily be done in the place from which the child has been taken. That would be the way that that would be addressed in incoming cases. Cases in which there's been allegations of domestic violence serving as a defense to the return of a child to the United States, the proposed legislation provides for a referral to competent legal services for victims of domestic violence, those who are asserting that they are victims of domestic violence, as a means of ensuring that all information crucial to the court in protecting the child when a return is ordered is available. The legislation calls for a study which will further amplify the life-altering impact which child abduction has upon its victims beyond any period of wrongful removal or retention. And I champion Dr. Hunter's request that that be done with all deliberate speed. I would note that interagency meetings have been less and less effective, have occurred less frequently, and have done nothing to address the appalling disconnection between DOJ and the State Department on issues involving child abduction and consideration of criminal prosecution. It is unfathomable to have a conversation with DOJ and have them tell you that this is in State Department's lap, and then talk to State Department and have them tell you it is with the DOJ. This was supposed to be addressed as part of the interagency issues. Ensuring the use of law enforcement resources in criminal prosecution to assist in the return of children who have been abducted swiftly and professionally provided has not occurred. This will have the additional advantage of encouraging United States attorneys to actually use the existing federal law. Because frankly, most are recalcitrant in doing so, in part because they do not understand the relationship between the Abduction Convention and the necessity or appropriateness of criminal prosecution. Finally, by enhancing the attention of the Department of Justice to work in collaboration with the Department of State, in pressing for the extradition of child abductors, and unflinchingly prosecuting those who have acted in disregard of orders preventing the removal of children from the United States, there will be an enhanced deterrent to consideration of parental abduction by parents. And there will be the understanding by the Department of Justice that child abduction is not a private matter between two parents who are disgruntled in the dissolution of their partnership or marriage. The importance of a dedicated ambassador at large has been demonstrated by the enormity of this issue and the testimony that you've received today. While extraordinarily skilled and experienced career diplomats have served in the role of special advisor on issues involving children, there has to be a renewed expertise and focus on child abduction as a human rights issue, inspired and executed by someone who will be recognized on the global stage as having the authority commensurate with the complex issues of international law which are implicated. I listened carefully to the question that was addressed as to seeking an MOU. I did not hear an answer with clarity. But what was important to understand in the three countries that were referenced, Lebanon, Jordan, and Egypt, all have complicated religious law that is embedded in the resolution of child custody issues. It's important to have an opportunity to walk through those issues in an MOU and to develop a process. identified by the country as to how the issue of addressing custody, wrongful removal, and retention may be done. My view is that the expertise in confronting the challenges of religious law may be something that has not been addressed properly, and perhaps working closely with the Office of Religious Freedom, working closely with the Human Rights Desk at the Department of State would enable engaging religious leaders in those countries in working those problems, in crafting an MOU, in addition to actually providing a draft, because I know that I haven't seen one drafted by anyone since those three countries entered the original agreements. In conclusion, a reading of 2023 ICAPA report of the Department of State demonstrates that in several countries, including some which we would otherwise undoubtedly describe as diplomatic allies, if not friends, international child abduction persists unchecked, and the existing protocols and remedies have not been effective to curb it. The actions which are now necessary in addressing systemic difficulties must be new ones. The world has been reminded by the International Criminal Court that child abduction is a crime and is in and of itself an inherent violation of human rights capable of causing inordinate pain and suffering with generational consequences. Ironically, those who are facile with the Hague Convention on the Civil Aspects of International Child Abduction had the opportunity to see it coming in declarations which were lodged within the last 8 years, which predicted the weaponizing of Ukraine's children. And that's what happens in these cases. These children are weaponized. There's also circumstances, in speaking to questions by Mr. Berra, India's numbers are going up exponentially. And there is an increased use of trafficking in the context of international child abduction for the purposes of obtaining financial remuneration. A child is abducted and demands are made to the left behind parent to provide financial assistance or support in exchange for promised but rarely provided access to the child. That's a child trafficking violation and should be included among the identifications of the harm that's being provided. I was deeply proud when the United States Ambassador to the United Nations, Ambassador Thomas Greenfield, her colleagues, along with the delegations of the United Kingdom, Albania, and Malta, walked out of the Security Council briefing being given by the Russian Federation Presidential Commissioner Lavona Bevlova. But there are other actions that can be taken that stand in the face of the constant excuses that are provided for what is clearly the lack of compliance. I do not understand the content of the Japan report. The request to understand what voluntary resolution means in these cases, or the question that you asked about the seeming inconsistency between references of appropriate judicial action and no case, listened carefully. She said there were return cases, but she did not answer your question indicating that a return had been accomplished by judicial action this year. And to my knowledge, there has not been one to the United States that was pursuant to a judicial determination under the treaty alone. There is a danger to be found in distinguishing different forms of child abduction or excusing abduction of a child by a parent or a relative as somehow less serious. This legislation empowers those within our government, our judicial officers, our law enforcement officers, our officers of Homeland Security, as well as those addressing child abduction throughout the country on the state and local levels, to have the tools necessary to prevent child abduction and restore those children wrongfully removed and retained to their homes. I would ask that there be serious consideration to requiring a list from the Department of State in response to today's hearings of those resolutions that are based on alleged judicial action in treaty countries that they have recognized as to be non-treaty compliant, and for which countries those judicial determinations have occurred. Because without that, there is absolutely no ability to determine whether or not a country is actually in treaty compliance. This is a reciprocal treaty. We are long past merely calling someone out as being non-compliant. It is important now for the Department of State to consider whether or not, in circumstances in which there is no actual reciprocity, whether or not there has to be a reconsideration of our treaty responsibilities, reciprocal responsibilities, to a ongoing condition of decades of lack of consideration of the treaty. I thank you.
Thank you very much, Ms. Appy, for that very comprehensive, and we have much to follow up on from all three of our very distinguished experts who have given so much to this cause. So I know I can't thank you enough for your leadership. We have embedded in our draft bill 3 tiers. It mirrors to some extent what we did with the Trafficking Victims Protection Act, and I am the prime author of that bill, or the law that was enacted in the year 2000. But even there, we ran into problems during the Obama administration. There was a time where the graders discovered, through an investigative report, that 14 different countries were artificially given passing grades that did not deserve them for other diplomatic issues. For example, Oman got it because they helped facilitate the talks with Iran and the United States and other countries in Europe for the nuclear deal. Malaysia got it because got an inflated, not earned grade off Tier 3, which is the worst, simply because they wanted to be part of the TPP, a trade agreement. Cuba got it because of a rapprochement that we had done as a country with Cuba, exchanging ambassadors and the like. It was like, well, okay, fine. But they still have an egregious trafficking issue there, both forced labor and sex trafficking. And China got artificially inflated to a passing grade, which I found appalling. Well, I chaired 2 hearings that year and into the next year. The second was next time get it right. And we focused on the fact that you can't falsify the information. It's got to be comprehensive, it's got to be real, it's got to be accurate. And then what you do with it in terms of sanctioning, because that has a sanctioning regime as well, is at the discretion of the department and the administration, but not the TIP report, the Trafficking in Persons report, not this report either. So I think we will get to a better place with tiers, but it still will require, I believe, an enormous amount of oversight. And as I think all of you have indicated, the prioritization issue is so important. This can't be something that is done where no one else in the building is affected. The Secretary of State did a wonderful cover letter to this, Secretary Blinken. But does he raise it? We just had the president of Korea here for a joint session of Congress. He had multiple meetings with the president and everybody else down the chain of command. Did anybody raise it? I didn't get to speak to him. I would have. I didn't get to speak to him. I wish I had that opportunity. But as we know, Korea is and they have a new government. I mean, the Moon government had huge problems with human rights, and its obsession with reuniting with North Korea, with Pyongyang, which I found appalling. Who's going to influence who? Is South Korea going to become more like North Korea or the other way around, which we would hope North Korea would become like South Korea. But again, they're on the list, and they are a friend. I remember when they were put on the Tier 3 list during George W. Bush's administration, and I would note parenthetically, Israel was put on the trafficking worst case scenario as well, Tier 3. Both of those countries went overboard to get off the list because they were potential sanctions were very, very real as a possibility, and both South Korea and Israel worked overtime to pass new laws and to implement a very good. So I think we need tiers, and I think we then need robust oversight to make sure that they are not manipulated in order to garner some kind of diplomatic gain with the country in question. Ms. Appy,
I just wanted to add that no one who does this work believes that the numbers in this report are accurate. No one. And it's really important to understand that in many of these countries, the applications, especially non-treaty cases, the applications are not made because there is not an identifiable mechanism. The other thing is that parents are not actually guided through the process or provided accurate information with regard to bringing an application. So I think one of the takeaways here is, yes, prevention has increased. Yes, there have been excellent efforts made in that regard, but these numbers are not accurate. And as a result, that is impacting both on prevention as well as return.
Yes, Dr. Hunter?
Thank you, Mr. Chairman. I just have to heartily agree with my colleague on the panel, and she just said it so plainly. No one believes these numbers are accurate. And when I read the report, it's also, I'll use your term, appalling that the information is recycled from year to year to year. So the content, the narrative is very similar. I could lay down the 2015 report and the 2023 report, and there is verbatim, content there. But then more importantly, the numbers are not accurate. And this speaks again to the recommendation to fund independent research regarding not just State Department performance, but federal performance overall. And then even extending that to how are other countries adhering to these treaty obligations, at what cost if they don't. And so I would just like to heartily agree and then say that this is absolutely why independent research is necessary for this problem. Thank you.
Yes, Mr. Morehouse.
Thank you. If I could add to that, and thank you for bringing it up, Patricia, that was really spot on. No one believes these numbers. I spent over an hour talking with an attorney on a case that I was brought into in Tennessee who had talked with the State Department and told everything was fine with Japan. They were non-compliant. By the end of the conversation, he said, I need about a day to process what you just explained to me. It's that confusing when people that aren't experts like Ms. Appy look at this report. Also, as we were entering into the hearing, I was talking to the special advisor a little bit, and interestingly, she brought up the comment of rhetoric versus action. She was speaking to somebody in the department, and I heard a lot of rhetoric from her. It was as though we were given a glimpse through a peephole, through a door. She mentioned in response to a question about returns that since 2021, all return orders that were made were enforced with Japan. We need to kick the door open and see what's really going on. What about the judicial rulings that were never made to require a return even be attempted? What about James Cook in his case, who's testified in this subcommittee more than once, who was the first known case with Japan, whose children were ordered returned, and then it was overturned at the appellate level and at the Supreme Court level of Japan, and those children never came home. What about my good friend Bjorn Enternach in Germany, who had a return order and whose kidnapping parent was able to abscond with the children and disappear into Japanese society, and the Japanese government did nothing? What about the other 500 American children who still remain cut off? She didn't want to talk about that. She's only highlighting a small glimpse of the story. So yes, disaggregating the numbers, modeling it after the TIP report, I think is essentially important so that, as Ms. Appy mentioned, attorneys and judges that are bringing these prevention cases in can see very clearly from the report, this is what's going on if we're considering allowing a child to travel to country X. And that is not what the State Department has been choosing to do. They could have done that since 2014. There have been numerous hearings that you have led, as well as hearings in the Senate, that have implored them to do it. There have been countless meetings we've had as coalition partners asking for them to release the numbers. So here we are. You've drafted legislation. It's clear years of work have gone into this, and we look forward to that being introduced and hopefully passed swiftly by this Congress and enacted into law so we can better protect American children from being kidnapped in the future, and also create more substantive, robust response from our government, a whole of government response, to start repatriating and reuniting kidnapped American children.
Just a couple of points, then I'll give you the floor for any final comments. We have raised so many issues with Japan over the years. I'll never forget Captain Paul Toland. Here's a guy that was given bad advice by his JAG. He was deployed to Yokohama. His wife, sadly, has passed away, and now the grandmother has sole custody, or at least de facto. And he hasn't been able to see his daughter, Erica, for all these years, like you, Jeffrey, all these years, in a gross violation of his human right, his daughter's human rights, and there's so many others like that. And, you know, it breaks you. I don't know how you persist. I can't say how much I admire your courage and your strength, because you're not just helping yourself, and you are trying to help your daughter, your son, I should say, but you're helping all the other people who have been left behind as well. Michael Elias, my chief of staff, Mary, and I went to Japan with Michael Elias's mother, because we thought that might be less confrontational to have her try to visit with their kids, 2 of them. And we were shown the door. You know, it was outrageous, frankly, that the Japanese government, we met a few people in the Diet and elsewhere that were empathetic and sympathetic. And then our embassy kept saying, but they're going to sign the Hague Convention. That's what we got to move towards. Yeah, if they do that, that's great. Leaves him behind and you potentially forever. So you know, I just can't tell you how disturbing that is. And we did talk a lot of other internationals. You know, we met with all the embassies that were in the area, and they had the same problem. And we talked about MOUs and the need for an MOU that was durable, actionable, that would really make a difference. And we got a lot of yawns. So I am very concerned about. Now, it comes down to prioritization. You know, I have found in human rights work, I've been in Congress 43 years. When you talk about human rights, there are so many people in the diplomacy orbit who just want to make that a page 6 footnote somewhere, rather than the mainstay of our relationship with the country. We see it with China today, with human rights being relegated to, well, what's that? You know, let's just trade more, even despite all of Xi Jinping's monstrous behavior and his, you know, what he's doing to the Uyghurs and everyone else. So I just bring that up. You know, it needs to be a priority. And, you know, we need people who are willing, and that starts with the president. And you, I think it was Dr. Hunter, you talked, or someone mentioned, you know, through successful administrations. Because we raised this with Trump, too, and his people, and didn't get a satisfactory implementation either. So we're going to keep at it. I'm going to form, I just thought of while we were sitting here, a caucus of members of Congress, and hopefully the Senate as well, for left behind parents and abducted children. And I would say it's important. We wrote it, Section 104, Report to Congressional Representatives, that the Secretary of State, this is law, this is in the Goldman Act, shall submit written notification to the members of Congress and senators or resident commissioner or delegate as appropriate, representing the legal residents of the left behind parent, and it goes on. The whole idea was to get us involved. And Dr. Hunter, you talked about how important it was to have Mitch McConnell, to have Hal Rogers and Senator Paul, all pushing and surging on behalf of your daughter. We need that everywhere. So I do hope, you know, that the administration will see us as value added, and then some, I would hope, because we then control the purse strings. One of my colleagues put a, you know, threatened Lebanon on behalf of one of his. You might want to speak. It was excellent. And all of a sudden, his constituent, who had a situation where they were very concerned that as his daughter, her daughter, you know, the woman who had children abducted, they were going to be put into marriage, and then she'll never see him. They got those children back because the congressman from Florida stepped in aggressively and said, okay, Lebanon, we're going to go after your purse strings. We're going to make it count because it counts for us. So I think you wanted to say something.
Yes, Dr. Hunter raised an issue that isn't reflected in my report, but I think it's important regarding the resources that parents have to expend in order to be even remotely hopeful in seeking a return. The United States took a reservation to the Hague Abduction Convention with regard to the provision of attorneys' fees and attorneys' assistance in the form of legal aid. I think it's really important to reconsider this many years later that issue. The United Kingdom, which does provide legal aid, Sweden, which does provide legal aid, provide it on the basis of every parent who is asserting a petition under the convention is entitled to have counsel who are expert in the issues of the treaty and its application under the domestic law, are paid by the government. Now, what that does is that the fastest return orders, the most consistent law in the world, comes out of the United Kingdom, comes out of Australia, comes out of Sweden, all countries that assure the provision of legal services. You cannot underestimate the possibilities of return being enhanced when you're able to understand the issue quickly, obtain the right representation, and make the right, make the right efforts. I said in one of the prior times that I've testified that effectively what we have made these parents do is become their own Department of State. They have had to make all of the connections. They've had to engage whatever assistance they believe they can and talk to anyone and everyone who would listen. We're not talking, if in fact these numbers that they're giving us are accurate, then you would propose that the United States Department of State should be able to quantify the number, to provide adequate legal assistance based on those numbers for the opportunity for parents to have legal representation in the courts in order to, and by the way, American citizens whose children are abducted to the United Kingdom are covered under legal assistance. And I have a case right now where the children were very quickly returned. That's one of the things that I think has to be looked at seriously. There's an excellent volunteer program that's instituted, and I serve on, and a number of other individuals do, but it's not the same as having an opportunity to know that you're going to have resource, and that resource is going to be able to quickly and effectively bring an application. I think it's time to relook at the reservation.
Yes.
If I could comment on that, and thank you for bringing that up. I think that is really important to understand. I had a case about 2 years ago that came to our organization with Japan, and in the end he said, I just can't afford to. And there's a lot of that, and I don't have an answer for that right now. You know, that's why, whether it's reviewing what Ms. Appy mentioned, or hopefully opening up the Federal Crime Victims Fund to make funds available. But I do like the idea that she's brought up. Hopefully that leads to actually vetted attorneys in those countries, because one of the problems I've seen with the State Department, at least with Japan, and I think this is true of other countries, they take all comers that want to be listed as potential legal resources on the embassy website, and then they put a big disclaimer on the top. And so what we've had to do with Japan is through our colleagues working in Japan and other countries is we've built an internal list of attorneys that we know that are fighting on the right side of this and have some level of expertise in the area. But right now, parents are just left to fend for ourselves. You get better support if your car is broken into than if your child is kidnapped.
Well, thank you, Ms. Morehouse. Anything, Dr. Hunter? If not, we'll...
Yes. Thank you, sir. Just a very brief closing statement. I just want to say that this hearing has energized our parent community. We watched the interest, which is demonstrated by parents here today. We watched it expand online, and it's been a weary time for a lot of parents between the time that we have had the Goldman Act enacted and now. And I know that there is hope among parents, a resurged hope that the bill that you are going to reintroduce and the actions that are taken here are going to redirect this issue. And so, you know, in appreciation for you and for all the members of the committee, and especially for all of the parents and families who, against hope and against what is before them, continue to believe that their children can come home. So thank you so much.
Thank you, Dr. I want to thank all three of our very distinguished witnesses. I can assure you we will redouble our efforts. Your insights are absolutely priceless. Your direction, your fervor, your compassion, it's extraordinary. And we're going to try to make a difference. Jeffrey.
Sorry, Chairman Smith. I just had a couple more comments if I could. Thank you. The special advisor mentioned in response to a question about children, victims that reach age 18, and they're making effort to contact them. This is something that I had worked on years ago. Our colleague in our organization, Randy Collins, worked on it in his case. I recently had one of our coalition partners at Children at Borders contact me and say he reached out, asked his country officer, his children were kidnapped to New Zealand, and was told there's no such program. So this is problematic that they're giving testimony to suggest that they are, as a matter of course, reaching out to children, victims after 18, if their own country officers are not doing this. So it's a little confusing, their answers. So I know this is part of the legislation. I look forward to that moving forward. Additionally, the interagency meetings, this has been touched on several times in today's hearing. We, Dr. Hunter and I, through our coalition of organizations, had requested to them a couple of years ago that we be allowed to sit in as observers, if not participants. We were told that was reserved for some nonprofit organizations, but not others. When we pinned them down more, the response was, well, we invite NCMEC to come, but they said, essentially, you're not welcome, but if you'd like to submit questions. I just want to point out that tomorrow there's going to be a celebration of the Department of Justice introducing the updated 5th edition of the Family Guide to Missing Children. Dr. Hunter and I and our organizations have been part of this. International parental child abduction is now being added to the guide. This is a DOJ-funded guide for the first time in its history, and our organizations are going to be listed as resource organizations in it. So I would argue we probably have a right to have a seat at that table at this point.
Well, I will officially make that request.
Thank you. And if you could also consider asking them if they are actually having presidentially appointed representatives from the departments as mandated by the Act at these meetings. We don't believe they are based on our conversations. I think there was just one other point I wanted to request. There were several parents that asked if they could make statements. Is it possible for written statements to be submitted by whatever deadline you want to set?
Yes, I would hope that it could be done. I ask the unanimous consent that additional testimonies, that's what you're talking about, be made a part of the record, and without objection, so ordered. So if you could get this to us as quickly as possible so they become part of the record.
Thank you. We'll do that. Thank you.
Thank you, and God bless you, and thank you so much.